All right. Hello again. This is Ben Hitchcock Cross talking to you today. I hope I've moved the slider up enough, but we'll see. We got yellow on all fronts here, so that's looking cautious. All right. Short headline of what we're going to talk about today is this. Administrative law judge, different area, hearing examiner for the Wisconsin Employment Relations Commission. And they put out an order that routinely is in excess of their powers. They were caught doing that. We're going to talk about their response. All right, stick with us. So, basically, it's like this: the WERC is it's the where you grieve an employment decision by the state of Wisconsin. So mostly this is state of Wisconsin employees. There's can be MPS. There's a few other things that have opted into it. Whatever. They make a just cause determination. That's not the 16 test of just cause, which everybody else recognizes. 7 test. I'm sorry. It's whatever they feel like it. Test of just cause. Whatever the commissioner decides. Test of just cause. Okay. So I was preparing for a hearing in a WERC case. Have a client who wants to state employee wants to get their job back, or comma wants to clear their good name. Another really good purpose of a WERC hearing, legitimate reason to have the thing. Okay. Now, one of the things you get is reinstatement. You get the whole, it's what in any normal union state you get, and what you would have gotten 30 years ago in any other side of employment here in the state of Wisconsin. But okay, Act 10. So their order says something like this: after 5 days or something from the final argument, you make your closing arguments at the hearing, the prevailing party needs to the worker needs to make a motion to the WERC for fees. That's what we're talking about, okay? I've won. I had to get my job back. You unjustly fired me. You need to pay my attorney, okay? When do you have to ask, or you closed out? Makes sense. So what did this thing say? This was what adds the strangest of everything else on that. It says, pursuant to Wisconsin statute, blah, 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 blah. We're giving you 5 days after the final thing. And, I'm just happen to be a lawyer. Just, one of the things I kind of do is go look at the statute. And when I read the statute, it said something like 30 days, 60 days after the final decision. Oh, okay. So they're saying 5 days after the hearing is closed, which is to tell you how much the reason why that's difficult and I haven't done this enough times to really know, but why I think this is difficult here is you have to get all of your fees ready to go and present it to them. It takes some time to do. It's not the fee petition is not the easiest thing in the world. So, okay. So I have another hearing that's coming up, and I tell this hearing examiner somebody else. And basically, it's 2 people here. I'm not going to get personal yet, but we'll see what happens. We've got an much more experienced hearing examiner who was a contemporary of my mother. That's what I understand. Then we have a new person who's got just a short history with her, which she used to be an employee of the department. She's an attorney working for the governor at the Department of Administration, doing these cases, arguing on behalf of the governor that these people should be fired in front of the WERC. So now she's moved over to an attorney working for the governor as a hearing examiner, hearing cases on behalf of the WERC. Some people call it work, and I just don't go for that. WERC to me. Okay. I just think there's too many connotations in work that just aren't inappropriate. Now, I raised this issue to this judge, the hearing examiner. Gosh. You say 5 days after X. The statute says X many days after Y. So, maybe you want to explain why you have something that's different than the statute, but I just want to be clear that we're going to follow the statute. So we also in there, I think, is fair enough as a request that you change the pre-hearing order, what you wrote down, and telling us what we have to do. That says, according to the statute, we're going to do X, and the statute says Y. I think you need to change this. So I get a response back from this hearing examiner saying something like, I agree that it would be premature to file a motion without a final decision, meaning I agree the statute doesn't say what you says it says, but I'm available to hear all motions, something along those lines. Okay. Now I don't know what the heck that means by any stretch of the imagination at all. And I have a surmise later, but I don't know what I'm available to for the filing of motions is. I want to be very clear to these people that I am paraphrasing. We could throw all these emails up there, but we're just paraphrasing here for today. So we go, I think, around and around on this 3 or 4 times where I'm like, well, I don't get what that means. And I assume that you're going to, if you agree, I understand the first part that you say it's premature. So I think we're on the same page that the law says X. I think it's obvious that your rule says Y. So can you explain or change what you're doing? Because we got this problem here. And we got like a couple of variations of the three answers of the bureaucrats, which is really like a non-answer. You can go talk to my boss, that's the same as you can go to WERC, right? Which means you have to put up with all this, and then maybe someday down the road they'll fix my mistake, even though I'm an attorney acknowledging that I'm not following the law. And I think that's where all this breaks down right there is an attorney cannot acknowledge that they're not following the law. So when we would going through this cycle here, I would say, well, you've acknowledged that the law is X and that your rule is Y. So now we need to get Y to be changed to X. That's all. And then it would just break down at that point. And then we got a series of, I have no further comment, which seems incredible to me because, again, without giving an explanation, which is a decision, it's impossible to know why you're doing something. Or it's also the case that it's not really a decision. A judge cannot merely say, because I said so. And that's what happened here. And we must have gone around on that 5 or 6 times. Lo and behold, by the way, I asked this hearing examiner at the beginning of the hearing a couple days ago to confirm that they were not having any ex parte conversations with anybody about this case. And as far as I understood, we got that confirmation. So, great. It's Monday. I might have duties elsewhere. I might be going along my day. Who knows what's happening here? And I might just get an email from the more experienced hearing examiner later that night, like 5 o'clock, something like that. All right. And it says 2 very interesting things. And most importantly, I would say, is it says WERC, WERC, understands that you have raised this issue. That's fascinating. And by the way, I'll just cut to the chase. I asked that hearing examiner the next morning who exactly he was referring to when he said WERC, because, it'll be clear in a second. But he says he's referring to the employees and the staff of the WERC, the crew, the gang. And I'm fascinated to know how he came to understand what the staff and the employees of WERC knew about my feelings on this issue. I'd be fascinating to know what that meant. And fair enough. That is what I would call a bureaucratic answer. And but of course he knew it was. And that hearing examiner is in his stage in state employment that there really is not a thing that anybody could do to him to change his opinion one way or the other. So you are in many ways asking, please. I totally accept that, or understand the reality. He is also not the chair of the committee, the thing, so it's also a different position. But so he explains that while there is this statute that says that it's X number of days after the final decision, it's their practice, it's their preference that they get this request for fees so they can wrap that all up in their final decision, which they are under a deadline. Remember, we've mentioned this before. The WERC judges have a deadline to make their decisions, whereas opposed to the ERD judges, for example, do not have any deadline. WERC, for example, has no deadline. Maybe they should. I don't know, because these things might come up like this. So he's then, this more experienced hearing examiner, requests that we place our motion into their record by 10 days from now or something like that, which is fairly reasonable. But you see, the difference there is that they explained what the reasoning was, what the purpose of it was, and then acted on the legal basis, which is a request. And this is a story more than anything about how sort of the bureaucratic preferences can become rules, and how they, particularly a new bureaucrat, is going to explain, a new attorney now becoming a judge, and this is completely unacceptable to say I have no comment about why the law says X and I'm instructing you to do Y. It's not weakness, hearing examiners, bureaucrats for the state of Wisconsin, to follow the law. It's not weakness to admit that you misunderstood the law. It's not weakness to correct your course and then follow the law. And see, we have to say that unlike the ERD here, who would have never sent out the second hearing examiner to convey the wishes of the understanding of the chair here, which is Ben, to back off here. We know that you're right, but we need your help here. All you gotta do is ask. Seriously. And that's one of, I would say, the fact that because of course I'm getting all these emails from Department of Administration, all these random people, state employees, are emailing me today for some reason. I don't know why. It's not like they don't communicate. Because they don't communicate. Obviously, we know for a fact that they don't, because they tell us they don't. But that there, in a nutshell, is exactly what the problem is here. I mean, this is, I guess, a limited hangout. It's something better. It's a step up. We want to completely acknowledge that it's absolutely better than a step up, and especially a step up from the Department of Administration as far as what they're doing to Teresa Folleron's case. It's a step up from the Department of Workforce Development for what they're doing in the Stolar case here. which is admit no wrongdoing and say, if you, yes, we're attorneys who are knowingly breaking the law, but sue us. And that's where they're at. So, um, I guess that is my real-time explanation here. I guess I can do that of how bureaucrats, how a preference of a bureaucrat becomes a rule for you, and how they are unable then when it's pointed out what the actual rule for them is, and that it's their preference and request, which again, perfectly understandable. We all want this decision fast. We all do. Both sides, the employer and the employee, want this decision back. They want the reinstatement quicker. Because everybody, I mean, that's the whole point is we want to go back to work. We want our name cleared. That's the whole point. But to tell me why when it's really X and then to gaslight me, we're not going for that. We're not. So, Department of Administration, Yellow Frenzy today. That's what y'all get. And for the rest of you, stick with us. We'll keep you informed.